In this topic, we shall discuss how the government of Kenya is formed. We shall look at the arms of government, their structure and functions. These arms of government of Kenya are the Legislature, the Executive, and the Judiciary. The Legislature is the arm of government responsible for drawing the laws that govern the country. This is referred to as the Parliament of Kenya.
The National Assembly is made up of 350 members, including the Speaker. The National Assembly consists of 290 elected members from constituencies, 47 women, 1 elected from each county, 12 members nominated by parliamentary political parties based on their strength in National Assembly, and Speaker, who is an ex-officio member.
The Senate, or the second chamber of Parliament, is made up of 68 members, including the Speaker. The membership will be as follows: 47 elected members from the 47 counties, 16 women nominated by political parties, 2 members, a man and a woman, to represent the youth, 2 members, a man and a woman representing persons with disabilities, and 1 speaker who is an ex-officio.
A person is eligible for election as a member of the National Assembly if he or she is a registered voter, meets education, moral and ethical standards set by an Act of Parliament, is nominated by a political party, or is an independent candidate who must be supported by at least 1,000 registered voters in the constituency in case of election to the Assembly, or at least 2,000 registered voters in the county in case of election to the Senate. Other conditions include: they should not be a state or public officer, not be a member of the Independent Electoral and Boundaries Commission (IEBC) for the last 5 years, be a Kenyan citizen for at least 10 years, be of sound mind, not be bankrupt, and not be a member of the county assembly. A person is disqualified from being elected as a member of parliament if he or she is a state or public officer, has been a member of the Independent Electoral and Boundaries Commission (IEBC) within 5 years before the election, has not been a citizen of Kenya for at least 10 years immediately before the date of election, is a member of county assembly, is of unsound mind, is declared bankrupt, and is subject to a sentence of imprisonment of at least 6 months by the date of registration as a candidate or at the date of the election, has misused or abused a state office or public office. A parliamentary seat can be declared vacant due to the following circumstances: death of a sitting MP, absence for 8 consecutive sittings without permission from the Speaker, if a member resigns in writing to the Speaker, if a member resigns from the sponsoring political party, if an independent MP joins a political party, if one ceases to be a Kenyan citizen, and if the electorate recalls the MP. Kenyan elections will take place after every 5 years. However, in case the country is at war, the Parliament, through a resolution of more than 2/3 majority in both chambers, can prolong the life of Parliament, but not for more than 6 months. In case of a by-election in either chambers, the respective Speaker shall notify the IEBC within 21 days. A by-election must be held within 90 days by the IEBC after this notification.
We shall now look at the functions of Kenyan Parliament at both the Senate and National Assembly. These functions are as follows: legislation, Parliament make laws; financial control, Parliament determines allocation of national revenue and appropriates funds for expenditure; legislature, review the conduct of the President, Deputy President and other state officers; Parliament approves declaration of war and declares state of emergency; Parliament checks the executive and the other arms of government to project the interest of the citizens.
The Parliament of Kenya, as is the case in the rest of Commonwealth countries, is supreme. It is above the other two arms of government, that is, the executive and the judiciary. Parliamentary programs and debates cannot be taken to court. The executive, too, cannot manipulate debates. Other aspects of parliamentary supremacy include the following. The Parliament makes laws that affect everybody throughout the country. Parliament controls government revenue and expenditure. Parliament cannot legally bind the successor, neither can one be bound by the predecessor. That is, each parliament session is independent. A member cannot be arrested for anything he or she says in Parliament. An MP cannot be arrested for crime committed outside while inside the Parliament premises. The Parliament has terminative powers, that is, can pass a vote of no confidence on the executive. It is the Parliament that declares war in consultation with the President. The national executive comprises of the President, the Deputy President, the Cabinet, and public service. The President has powers bestowed on him by the Constitution. They include: President is the head of state and government. President is the Commander-in-Chief of the Defense Forces. President is the chairperson of the National Security Council. President is the symbol of national unity. The President also has various functions. Among them are: officially opens Parliament after general elections, chairs cabinet meetings, chooses cabinet members with the approval of the National Assembly, ensures that the international obligations of the Republic are fulfilled through the relevant cabinet secretaries. The President performs other executive functions, for example, establishing an office in the public service. Let us now look at the functions of the Deputy President. The Deputy President is the principal assistant of the President. He or she deputizes for the President in the execution of his or her functions. The Deputy President acts as the President when the President is absent or is temporarily incapacitated. It is a constitutional requirement that the Deputy President shall not hold any state or public office. We are now going to discuss the composition and functions of the Cabinet. The Cabinet consists of the President, the Deputy President, Cabinet Secretaries, and the Attorney General, and not fewer than 14 and not more than 22 Cabinet Secretaries. Cabinet Secretaries should not hold any other state or public office. The Secretary to the Cabinet takes minutes during Cabinet meetings and links the Cabinet with the public office. The Cabinet has the following functions. Advisory role. The Cabinet advises the President on various aspects of government policies. The Cabinet Secretaries' ministers advise the President on the affairs of their ministries. Defending government policy. The Cabinet has collective responsibility of defending government policies. Cabinet Secretaries are expected to make presentations or clarify issues they are responsible for to the National Assembly or Senate whenever they are required. They should also uphold the Constitution and act according to it. They should provide Parliament with full and regular reports concerning matters under their control. The Attorney General shall be appointed by the President with approval of the National Assembly. He or she is the principal legal advisor of the government. He or she represents the national government in court and any other legal proceedings. He or she promotes and upholds the rule of law and defends the public interest. The Director of Public Prosecutions shall be nominated and, with the approval of the National Assembly, appointed by the President. He or she shall hold office for a term of 8 years and not eligible for reappointment. The Director of Public Prosecutions directs the Inspector General of the National Police Service to investigate any information of criminal conduct. He or she institutes and undertakes criminal proceedings against any person before any court. He or she protects the interest of administration of justice and prevents abuse of the legal process. The public service is the section of the executive of the government which is headed by the Secretary to the Public Service Commission. It is composed of principal secretaries, state departments, and public servants. An independent public service commission ensures that the functions of the National Public Service are effectively carried out. Its functions include establish and abolish offices in the public service, appoint persons to hold or act in those offices and confirm appointments, exercise disciplinary control and remove persons holding or acting in those offices, investigate, monitor, and evaluate the administration and personnel practices of the public office, to develop human resources in the public service, and evaluate and report to the President and Parliament on the performance of the Commission. We are going to look at the national security. There are three organs of the national security, namely Kenya Defence Forces, National Intelligence Services, and National Police Service. We shall now discuss the composition of each of these organs. The Kenya Defence Force is composed of the Kenya Army, the Kenya Air Force, and the Kenya Navy. Their functions include responsible for the defense and protection of the sovereignty and territorial integrity, assist and cooperate with other authority in situations of emergency or disaster, and may be deployed to restore peace in any part of Kenya affected by unrest or instability. The Constitution provides for the establishment of a National Intelligence Services. Its functions include responsible for security intelligence to enhance national security and performs any other function prescribed by national legislature. The National Police Service consists of the Kenya Police Service and the Administration Police Service. Its functions include maintaining highest standards of professionalism and discipline among its members, preventing corruption and promote transparency and accountability, complying with Constitution standards of human rights and fundamental freedoms, training staff on the highest possible standards of competence and integrity, and fostering and promoting relationship with the broader society. The correctional services are government institutions that are charged with the responsibility of rehabilitating convicted criminals. The functions of correctional services include complementing the work of national security organs, containing the prisoners as they serve various jail terms, executing court orders by implementing the decisions of the law courts with regard to how the convicts are to be punished, offering security to convicts while in detention, rehabilitating and reform convicts by changing their behavior, generally looking at the welfare of the prisoners in areas such as health, food, and shelter, providing labor in some national government projects through the extramural employment scheme such as afforestation, digging canals, and building roads. In this lesson, we are going to study the structure and function of the judiciary in Kenya. The judiciary in Kenya consists of judges, magistrates, and other judicial officers. The head of the judiciary is the Chief Justice.
How is the court system in Kenya structured? The court system in Kenya has the following features. Under the Kenya Constitution, the Supreme Court is the highest court. The second highest court in Kenya is the Court of Appeal. The High Court is the third highest court in Kenya. The above three are referred to as superior courts. The subordinate courts comprises of magistrates' courts, Kadhi's courts, and the courts martial. The Constitution empowers Parliament to establish the subordinate courts and tribunals as it may seem necessary. The judiciary in Kenya performs various functions. These include interpreting the application of laws in Kenya, adjudicating in both criminal and civil court cases, settling disputes between conflicting parties or institutions in the political structure, protecting the constitutional rights and freedoms of individuals, collecting fines imposed on those found guilty of various offenses by the courts, administering the swearing-in of senior government officials, for example the president, before he assumes office. Click on the court to view its function. The concept of the rule of law entails the process of handling all legal matters in accordance with the law. All Kenyans are subjected to and governed by the same laws irrespective of their status, color, or religion. It stipulates that no person is above the law. Matters pertaining to law are dealt with in accordance to the law. A person is presumed innocent until proven guilty in a court of law. The concept of natural justice stresses that a suspect should be treated fairly by the courts. The following principles of natural justice must be upheld before any judgment is made on a suspect. The accused person is given the right to fair trial. Suspected persons are presumed innocent until proven guilty in a court of law. This concept discourages mob justice. An accused person is entitled to legal representation. A suspect is given an opportunity to defend him or herself in a court of law and call for witnesses. All judicial decisions are based on law.